Hello, my name is Referee Mark Labine. If you are scheduled to attend court in a harassment restraining order case, this video will help explain what to expect and what is expected of you. Because of COVID-19, we are holding court most of our hearings using remote technology such as Zoom. If you cannot appear remotely, you may appear in person. Please follow all courtroom decorum rules, whether your hearing is in person or held remotely. You should remain quiet or muted until it is your turn to speak. Do not interrupt others when they are speaking, and you should not record the hearing. Please sign on to the hearing remotely or come to the courtroom at least 5 minutes before your scheduled hearing time. The court will let you in to the physical or virtual courtroom when it is time for your hearing to start. There will be more than one case scheduled at one time, so please be aware that other people will be in the virtual or physical courtroom and you may have to wait. The judicial officer at the hearing will manage the cases. The judicial officer's job at the first court appearance is to act as a neutral third party in helping you reach an agreement or scheduling your case for a trial. The judicial officer can make a final determination in a case if they determine there are no fact questions for a trial. When you appear for your first court appearance, the judicial officer will require you to state and spell your name for the record. If both sides of the case are present, they may require you to attend mediation to try to reach an agreement. The judicial officer will have reviewed your case before the day of your hearing to decide if mediation is appropriate. Mediation is a process where a trained person meets with both sides to the case separately, hears the concerns, and brainstorms ideas for solutions to try to work out an agreement. Mediation has benefits for both sides. You get a decision on the day of the first court appearance, and you do not have to appear again for a trial. You get to decide your future, even if that future has a restraining order in place. Being able to make those decisions for yourself versus someone else telling you what to do can be very powerful. Finally, you can be creative in your solution. Many cases involve families, neighbors, or friends. This court will only issue orders restricting a person from going to a specific location, website, or phone number. Often, there are other issues you would like to resolve, and you can do so during mediation. You can be creative in what your outcome might be. We see agreements ranging from simple apologies and a dismissal of the case to both sides agreeing to have restraining orders in place. At the start of mediation, the mediators will give you a brief orientation. The court will not know what you discussed in mediation, and if you are unable to reach an agreement, that is okay. The court will most likely then schedule the case for a court trial. As you think about settlement and weighing if a trial is a good idea for you, it is important for you to know a little bit about what the law says and the procedure of a harassment case. At this point in your case, the person who wants the restraining order, called the petitioner, filed paperwork with the court. That paperwork was sent to a judicial officer who looked at it and said either yes or no to a temporary restraining order. If the judge said yes, the paperwork and the temporary restraining order were served on the other person, called the respondent. Then, the respondent asks for a hearing because either they disagree with the facts in the paperwork or they do not think the facts meet the legal requirements for harassment. If the judicial officer said no, and the person who wanted the restraining order asked for a hearing, you were given a notice that there would be a hearing. The petitioner has the burden of proof in a harassment case. The petitioner has to prove the facts in the petition are more likely true than not true, or in legal terms, proven by a preponderance of the evidence. Also, those truthful facts must meet the legal definition of harassment, which is, number one, a single incident of physical or sexual assault. Number two, a single incident of sharing private sexual images of the petitioner without the petitioner's consent. Or three, repeated incidents of intrusive or unwanted acts, words, or gestures that have a substantial negative effect or are intended to have a substantial negative effect on the safety, security, or privacy of another person, regardless of the relationship between the people. At your first court appearance, the judicial officers may swear you in to confirm your agreements or the things you've said, but there will not be any witness testimony or any evidence collected. Those activities will take place if a trial is scheduled. With this information, we hope that you are able to meaningfully take part in the process. Thank you for watching this in advance of your hearing.